Recently, Romeo Lacoste, a tattoo artist in Los Angeles, sued Keemstar of Drama Alert in federal court for $3.5 million over Keemstar's accusations that Romeo is engaged in inappropriate behavior. Romeo famously responded in the lawsuit by saying, "Well, I was engaged in that inappropriate behavior." And as such, the court dismissed his lawsuit entirely, granting Keemstar the victory. Now, Romeo is appealing that decision. Let's talk about why that might be a bad idea. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and today we're talking about Romeo Lacoste and Keemstar's lawsuit a little bit more because it keeps getting funnier. Okay, as I said in the introduction, the lawsuit has been dismissed. Keemstar has won and Romeo has lost. Now, there is still an ongoing fight over the fees. When you win on an anti-slap motion, as Keemstar did, you are entitled to reasonable costs and fees, including the fees you paid your attorney, so long as those fees are reasonable. Keemstar has filed his motion to get fees. The total comes out to between $150,000 and $160,000. These are very, very expensive lawsuits involving very expensive lawyers. Now, Romeo, his lawyer, Raul Severo, has filed an opposition to Keemstar's motion for attorney's fees. Now, what you should be doing in this opposition is arguing for a reduction in the amount of attorney's fees based on the fees being unreasonable. But Raul went all the way to the point of not doing that and instead arguing that the fees should be dismissed entirely, which would be an extraordinary sort of judgment for the court to come to and is very unlikely to prevail on that sort of motion. Of course, it's possible that a court would do that, but they would have to determine that the behavior of Keemstar's attorneys in their motion and that their request for fees was so egregious that it warranted dismissal of all of the request, or denial, I should say, of all of the requests, rather than just a reduction. The proper way to argue this would be to argue that the hours spent, the hourly rates, and the work done was unreasonable. And unreasonableness involves duplicating work or overbilling or charging for things unrelated to the case. Romeo's attorney argues for this a little bit, but not very well, to put it lightly. In fact, he actually lifts, without really attributing it, about 5 pages from an existing court decision that doesn't really have to do with the subject that he's arguing here. It's kind of a terrible filing, and I'll be going through it on a live stream. If you want, you can check out my live streams, which run basically every weekday at 11 p.m. Central Time. That's neither here nor there. What we're here to talk about today is now Romeo is appealing the dismissal of his action. Now, in anti-slap motions, in anti-slap motion practice, I should say, generally an appeal is going to come because the cost of the loss for either party is so great. You lose the entire lawsuit right out of the gate. You don't necessarily get to even make the main arguments. In Romeo's case, he doesn't get to defend himself against the accusations of Keemstar. Were this a perfect world and were the lawsuit not absolutely ridiculous, that might be a problem for Romeo. Instead, what Romeo did in this lawsuit was to admit to everything Keemstar said about him and then sue him anyway. And that's why this appeal is fatally flawed as well. Romeo's own documents, not something that Keemstar compiled and clipped down and maybe put out of order to infer something. That's not what happened here. Romeo's own documents admitted to the behavior that Keemstar was accusing him of. That means when the record that's before the trial court goes up to the appellate court, they're going to read the same thing. they're going to read Romeo Lacoste admitting to the things Keemstar accused him of. They're going to read all sorts of different, very salacious details about Romeo Lacoste's interests, we'll say. And in doing so, they're going to most likely come to the same exact conclusion. Now, why is this particularly bad for Romeo? Well, he has already lost. He's already lost, and he will be ordered to pay some amount of fees. That decision hasn't come down yet, but if the court were to grant Keemstar's entire request, that would be up to $160,000 in fees. If the court trims it by, say, 20%, we're still talking about $125,000 in legal fees that Romeo will be ordered to pay. Now, to perfect this appeal, to make the appeal right, and then therefore to stay the enforcement of the judgment pending the appeal, Romeo has to put up a bond valued at whatever the fee award is. He has to actually put money into the court and say, no, I guarantee this will be paid if I lose. And he'll probably have to get some contingent fees as well, contingent upon the cost of the appeal, because the appellate court, if they decide to uphold the lower court's decision, may impose even further fee requirements on Romeo because it's costing Keemstar more money. And if it costs Keemstar more money and the lawsuit underlying the action is frivolous, then he shouldn't have to pay it. Romeo should. So what Romeo has done now is he has appealed a decision in which he has admitted through his counsel to everything he's been accused of. Explicitly admitted it without prompting, without trickery or deception from the other side. It's in his initial filing that he did what he was accused of doing. So, because of that, he is very unlikely to prevail on the appeal. Although, in fairness to Romeo and his attorney, they have not filed their actual appeal document. They've just filed a notice of the appeal, which we can look at real quick just so you can see it. It's very, very basic. It says the name of the court. It's got the case number, the date it was filed, the date the judgment that they're appealing was filed, and then it has the parties listed. That's about it. It doesn't really have much more information on the the notice of appeal. So we have to wait for the actual appeal document itself to be filed to find out their legal theory as to why they think they will overturn this decision. So I want to be fair and balanced on that, although I think it's a stretch to suggest that he has a reasonable avenue for appeal in this case. That being said, we won't know until the appeals court actually renders judgment on it, and we will be watching it until then. But this is a particularly bad idea for another funny reason. Appeals cases tend to get more attention than district court cases. In fact, especially if there's some new area of law that gets refined out, the appeals case could be published in a federal register, which means that Nico Lacoste or Romeo Lacoste's admissions about his own behavior could take front and center stage in like a law school textbook at some point in the future. Now, is that likely to happen? No, this is a pretty straightforward case, and I don't think they're going to have many areas of appeal that would create some sort of new law, although if I'm correct on their theory, their main theory is going to be something like the party admission should not be admissible as evidence against the party, which would be nonsensical. But that's what they're going to have to argue. They're going to have to argue that Nico's own words should not have been used against him when he chose to file those words in his pleading document. So we'll see what they do. This is probably an ill-informed decision on Nico's part, but Romeo, his real name is Nico, his nickname is Romeo. This is an ill-informed decision on Romeo's part, and we will see what happens with the fallout. If you guys like these legal updates, hot takes, and education bits, please go ahead, like, subscribe, share, tune in for a live stream sometime and see if that's something you like. Those are a little bit different from these videos, but all fun, all some sort of legal theme relating to it. And yeah, I hope you found this informative. If you did or didn't, have a good day. Peace. Peace.